Hi, everyone. Thank you, Chris, for having me here, and thank you, everyone, for tuning in. I like talking about diversion. It's one of my passions, and so I'm really happy to be here. My experience with diversion goes back to about 2006. I started at the Manhattan DA's office in 2000. And I'm going to tell you a little bit about my experience from the beginning, because I think it will shed a lot of light on where we were and where we are now. And it's been a long, there's been a lot of progress in the last 20 years. New York County is probably different than many of the counties that you guys are from. We're huge. Every year we indict about 3,500 cases, about 6,500 misdemeanors, and we are really resource rich in terms of what the community has to offer. There are programs that deal just with the criminal justice system, and then in every single community throughout Manhattan, there are all sorts of community-based programs that have nothing to do with the criminal justice system, but nevertheless are ones that we can tap into. So while our story may not be directly transferable to your jurisdiction, there are definitely nuggets of how we started that I think will be transferable. And so basically this is our origin story. I started here about 20 years ago, and my early experience was very typical, I think, of assistant DA's experience back then in terms of programming. Programming was very defense driven. It was driven in the who got it, the what, which program, and the how, the monitoring. And so, I indict a felony, a defense counsel would call at some point during the prosecution and say, hey, my client has a substance use disorder, and I found a bed at a residential facility. What do you think? And I, like most prosecutors, would look at the rap sheet. If the person seemed to be within our tolerance of risk, I'd say great. And I felt good about it because I was doing something for the community, for that person. Had the best of intentions, but the truth is, there wasn't much vetting of the individual person. Did the person have an actual need that contributed to the particular issue that caused the crime? There wasn't much vetting of the what. I relied on defense counsel. We all relied on defense counsel. They would bring the program, and if the program sounded, familiar, then we said okay, especially if it was residential, because residential feels jail-like, it feels punitive, but we didn't necessarily know, or it wasn't even at the top of our minds as to whether the residential treatment was the right fit for the particular individual. Questions about licensing and other items about the particular program, what were their hours, what kinds of services do they provide, again, weren't fully investigated. And then, of course, the how the monitoring was done was quite defense oriented. So, we would appear in court, and rather than affirmatively reaching out for program updates, they would be supplied by the defendant himself, sometimes of questionable authenticity, not very specific. They would say things like, defendant so-and-so is participating in our program. So what does participating mean? Does that mean going every day? Does it mean more than, physical presence? Is the person actually engaging and doing the work needed to happen for the person to stop recidivating in the future? And so it was, again, very defense driven. It was also done by judges with really varying levels of experience. Some believed in programming, some did not. Some, really connected with participants, which we know now is super important, and others didn't. And so there were really varying levels of experience. There was no resource for ADAs to go to. Look, we're all lawyers. There was no counseling department, social work department in the DA's office. Whatever knowledge an individual ADA gained by working on a particular case basically stayed with that ADA. There was no sort of central repository for information or expertise. And then fast forward to 2009, the Drug Law Reform Act came into being in New York State. It dismantled the Rockefeller drug laws, and the last bit of those laws implemented felony drug courts, which were slow to come to New York County. And we saw what really good problem-solving courts could do, what they meant. They were organized, we had experts, and there was eligibility criteria, and there was one judge who was super knowledgeable. We knew people were being placed in great programming, and we were getting updates that were very detailed. And so, it took the burden off of defense counsel. It was more neutral, and we really liked it. But we also saw that problem-solving courts too have their limits. As great as they are, there are strict criteria to get in, diagnoses, charges. And so when an individual didn't fall within the four corners of eligibility for a program, and everyone thought the person should be in a program and that was the right disposition for the community, we would default back to this chaotic, haphazard, defense-driven system. And that was not that system existed alongside of the problem-solving courts. And so we saw that duality, and then things started to change. There were a number of catalysts that really moved us, I'd say from 2010, 2012 on, to start thinking about how we could change the dynamic in our office in New York County as to how we were doing this. So look, we got a new DA, DA Vance was elected, who is more progressive than his predecessor. There was beginning to be a push to close Rikers Island and to reduce the jail population. There were new kinds of drug usage. K2 synthetic cannabis emerged. We saw, of course, the explosion of opiates and the emergence of fentanyl, deadly, very deadly. We saw more of an acceptance of medication-assisted treatment like Suboxone and Methadone, which our office did not have a taste for before that. And so, look, we saw that there's a new system out there, there's a new world, and we really needed to keep up with it. One, to be relevant, and two, to really promote public safety, because we were seeing that smart, prosecutor-driven public diversion could be done in a way that was intentional and organized and driven by us. And that's really what we aimed to do. And so our goals were first to change the paradigm from this defense-driven system to a prosecutor-driven system. And if you think about it, it makes a lot of sense, because our goals aren't always necessarily aligned, or most often aren't aligned with defense lawyers' goals. A defense lawyer is tasked with defending their client, which most often means getting out from under the charges, getting a case dismissed, negotiating the best sentence. And that all does not necessarily mean taking a guilty plea and then entering into treatment, which can be difficult. Sometimes our goals align, sometimes our goals of public safety and reduction of recidivism align with the defense lawyers, but not so often. I always think of it as sort of like this Venn diagram, the defense goals and our goals, and sometimes there's that alignment, but not always. And so we needed to be able to be in the driver's seat in order to push our own goals. So in addition to changing the paradigm, we wanted to consolidate our
We have
ATI.
5 minutes left.
Oh my goodness. All right. We wanted to change the practice, to consolidate our ATIs, to create a resource for ADAs, to establish a system to track usage, to identify gaps in programming. And so let me go to what the steps we took were in order to achieve those goals. So first and foremost, I went out and I had this tremendous 6-8 months where basically I pounded the pavement with an assistant, and we visited over 80 providers that had about 150 programs. We interviewed people from just reception to board members to clinicians, whoever we could speak to, and we did it in all sorts of programs: mental health, substance use disorders, employment, housing. I spent 3 days going through the homeless shelters if I was homeless, and it was eye-opening. We spoke to Medicaid. Medicaid was being redesigned at the time. And what we did was we became experts in this area. We learned best practices, the science behind doing diversion, which was something totally new to us, risk, need, responsivity, Andrews and Bonta. We weren't inventing something. We were really just becoming familiar with the principles, the science behind behavioral change, which is really what diversion and what we're about. And so after we visited places, we created just a very basic spreadsheet. I hired an amazing IT person to help me geocode the different locations on a map, and we superimposed it on a subway system, so we were able to direct participants to good organizations. We hired staff. We went from a staff of 1, me, to 7 ADAs and 8 case coordinators who were in charge of interviewing defendants and helping make treatment plans and getting updates. And we designed protocols and standardized plea agreements to make sure that individuals who were similarly situated were being treated similarly, to make sure that the criteria for graduating was clear. This was going to be the length of the mandate. You had to get a job, a place to stay, things that made, again, for strong ties to the community, and things that really are markers for reducing recidivism. We also took the show on the road internally. So, it's the idea of programming, sometimes gets a bad rap. Real prosecutors, send people to jail. They don't do programs. And so we had a lot of convincing to do of our very senior people. And, it's corny, but what we said was, look, programming is not being soft on crime, it's being smart on crime. You're getting a better result more cheaply. And if you do it the right way, you're going to get exactly the result that you want. And so we did a lot of convincing. I'm going to wrap it up. I know I just have a few more minutes or two, just to talk about our version 2.0. So we launched the ATI unit, probably officially in 2017. And since then, we have opened a catch-all ATI part. So we not only have problem-solving courts dedicated to substance use, to mental health, and to veterans, but we have this catch-all part where individuals who maybe don't fit into one of those particular problem-solving courts are able to get treatment. Thank you. One last shameless plug: we are right now putting into place an emerging adult court into our ATI court, which is super exciting. This is going to be dedicated to individuals who are ages 18 to 24, and we're designing a track just for them. So this is how we did it, and I'm really proud of how far we've come.